All right, with that, Darrin, if you can take it away. I'm going to skip the start in here and in here and just dive right into what is a preliminary report.
Well, good morning, everybody, and thank you for joining us. I'm here to talk about the very exciting title insurance policy and what the preliminary title report does. Um, so typically what we're looking for is this is what a preliminary report is. And if you kind of read through this section, and I'm not going to bore you with reading everything that's in there, but a preliminary report is a report that's issued when you apply for a policy of title insurance, whether it be an owner's policy or a lender's policy, residential or commercial. Um, what we show on a preliminary title report are items that are not going to be covered on the final title policy. And a lot of people get that confused. I get a lot of calls that say, hey, I have this, I need to add it to the report. And it's like, okay, if we miss something, we'll be happy to add it, but understand that those are things that we are not willing to cover on the final title policy. And it's our way of letting everybody know what we found as to the vesting, voluntary and involuntary liens, and things of that nature. It's very important that everybody, your buyer and your seller, the lender, everybody reviews the preliminary title report and understands what items are shown on it and that they're not going to be covered. It's typical company policy that we require signatures from the buyer and the seller stating that they have read the preliminary report and that they understand it. If you ever have any questions about the preliminary report, you're always welcome to call your escrow officer and of course the title officer, and then we can explain what those items are and how they affect the property.
Oops, let me go back.
You're where you want, right? Okay.
Yep.
So the big four key items to look for in your preliminary title report. And number one, your name on title. Is your name reflected appropriately on the preliminary report? If you're the buyer, are you going to take title as Jane T. Doe or Jane Doe? And these are all very important things because the document has to be drawn up in the escrow side for the conveyance of the real property. And that goes for the seller as well. If you're a seller on a piece of property and you think you hold the property in your trust, and our report comes out that you hold it husband and wife as joint tenants, then we need to let us know, that you were thought you had the property in trust, or if you had something that was done that we weren't aware of. Because our reports are written, but they're typically about 2 to 3 weeks behind the actual date of as we sit today. So, today is the 21st of March. Our report could be backdated at least 2 weeks. And the reason for that is we have to take every recorded document that gets recorded with the county recorder's office. We have to review them. We have to film them and then post them to our arbitrary account runs. And so we typically run about 2 weeks behind. Um, Liens, number two, are there any liens attached to the property? Types of liens that may be included: failure to make payments on auto loans, past due child support, unpaid homeowners associations. The preliminary title report will show voluntary and involuntary liens. A voluntary lien would be something such as a deed of trust that you purposely put on the property. Maybe you bought the property, when you acquired it, you had a deed of trust, or you refinanced, or you took out a loan. Those are voluntary liens. Involuntary liens would be things such as child support judgments, federal tax liens, state tax liens, county tax liens, abstracts of judgment, and things of that nature. Those would be all involuntary lien. You have to understand when you're looking at property or a preliminary title report, if you have a judgment or lien that's recorded against you, it automatically affects any and all real property that you own. It doesn't have to name it on the judgment. It doesn't have to give your address or the house. All it has to do is record against your name, and then it attaches to any and all property that you own. So the preliminary report will be looking for voluntary and involuntary liens. Um, as well as restrictions, things of that nature. Which brings me to item number 3. Restrictions. Are there easements, covenants, or other restrictions on the report that can impact the way that you, the buyer, intend to use the property? Well, this is very important. If you have a piece of property that you're looking at, and maybe let's say you have a young couple just got married and buying their first home. Well, they're not savvy to the real estate industry. And his wife has been to that property 5 or 6 times and through the escrow, and she knows exactly where she's going to put her spa. She knows where she's going to put her pool and her gazebo and her built-in barbecue or whatever else it may be, or even the kids' sandbox or something of that nature. And she plans and plans and plans. They buy the house and they, okay, we're going to build our pool now. And they go to the county or the city and they get an application to build it. And the city says, no, you can't build that gazebo or you can't build that pool. Well, why can't I? Well, because you have a gas line easement that runs right under that property where you want to put it. Well, what do you mean I have a gas line? Well, you can't put something on top of that gas line, that top of that easement. And then they're going to get very upset. And who's the first person they're going to come yell at? You, the real estate agent, right? They're going to call you up. I can't do this, this, and this to my property. How come you didn't tell me? And that's when and then you're going to turn around, call your escrow officer, your title officer. Hey, what about this easement? And then come to find out, title officer reviews it, looks at it and says, oh yeah, there's an easement right there on your preliminary title report and your policy running right across the property. So that's why it's very important that you review the report, take a look at it, make sure you understand some of the items on there that you can explain to your customers. Now, I'm not saying you have to be a title officer or work for a title company and be able to explain every little item of the report, but I think it's very important that when you have enough knowledge to understand what certain items are doing on the report, it's very beneficial for you and your customers. So you say, hey, here's an easement across the property. Just want to make sure you're aware of that. Things of that nature really help you in the years to come. Restrictions can also have restrictions on what you can paint the color of your house. Certain homeowners associations, you can't park your RV. You can't park your car out in front of the house if it has your company logo on it. These are all things that homeowners associations may have built into their restrictions. So it's very prudent of you to review those restrictions with your customers, especially your buyers, to make sure they understand that the property that they're purchasing has restrictions and these are what the restrictions are. There's always going to be, we will always provide copies of the recorded documents upon your request. Restrictions would be one of those, but we would provide for you that your customer can look through and make sure they understand some of the restrictions on the property, because they can range from you can't have chickens on your property to you can't paint your house blue. So it's very important that you review those restrictions. Number 4, up-to-date preliminary report. Is the preliminary report up to date? Should the report be more than a few weeks old? Please contact us if you see there are any changes, supplemental reports. Well, again, I kind of touched on that a little bit. We typically run about 2 weeks behind the actual date, but we do date those files down all the way up into the day of recording to catch anything that might have happened between the issuing of the report and the actual closing of the file. We date them down all the way up into the date they record. We actually would grantor with the county recorder's office, just looking for liens, things that might have happened. And then we would report on those all the way up to the day of closing. If we did find something on the day of closing, then we may hold the recording up until we can, let's say it was a deed of trust or an involuntary lien. Well, then we would have to get a demand ordered and see if there's any money owed on these and get a release or reconveyance before we could issue the policy. The reason for that, if you have a lien against the seller and the buyer is buying the property, we issue that buyer a homeowner's policy of title insurance. We're protecting them from any liens or judgments or voluntary or involuntary which are not shown on a report, um, from them taking a claim on it. So that's how we would take a claim. So we would make sure those items are taken care of prior to closing out the file. Next slide, Jen. There's really two types of, well, we have a few types of policies of title insurance, but the ones most commonly dealt with is we issue an owner's title policy to the buyer. And if they have an institutional lender or a private lender that requires a title policy, we will issue the lender's title policy. For all you commercial people out there, we also have a leasehold policy. This report is really kind of set up for the residential side, but they're pretty one for the other when it comes to commercial, except for you may have a leasehold interest instead of a fee interest. And we will talk about that more in a little bit. But we also have a leasehold policy. Let's say that Amazon wants to come lease a big building and they want a leasehold policy of title insurance. We can issue those, which just covers the lease interest and not the fee interest. Owner's title policy. An owner's policy is usually issued in the amount of the real estate purchase. It is purchased for a one-time fee at closing and lasts as long as you have interest in the property. So what that more or less is stating is title insurance. Let's take car insurance, for example. You pay a premium to your State Farm insurance, and it covers you from anything that happens to you from that time forward. A title insurance policy is just the opposite of that. You pay a one-time fee and it covers you from the time that you record backwards in time about things that may affect the property. Okay. So because of that, it's a one-time fee. It's not an ongoing, you got to keep paying and paying and paying every month like you would your auto insurance. You pay a one-time fee and it's good for as long as you own the property. So let's say Erin Rowe bought this house and she received that title policy. And in 30 years, somebody pops up and says, hey, I have an interest in Erin's property, and Erin still owns that property the same way that she closed that transaction with us. That policy and title insurance would still be good and in full force and effect. And our company would then protect you from any loss that may occur by whatever litigation you may face. Okay. A lender's title policy. The lender's title policy, on the other hand, is only as good as the date that the loan is still of record. So if you pay your loan off and the lender reconveys that deed of trust, then that policy, that lender's policy, then dies with the reconveyance of the deed of trust. It's no longer in effect because the deed of trust is no longer a lien of record. Most institutional lenders are going to require a title insurance policy. I don't care if it's commercial or on the residential side. If you're buying a piece of property and you have to borrow money from a Wells Fargo, a Bank of America, um, Fannie Mae, Freddie Mac, whoever it may be, that lender is going to require that you get a lender's policy and title insurance, which protects the lender's beneficial interest in the property. Next slide. So these matters are shown in the report as follows. Once we get to the actual report and we look it over, we're going to see that the estate of interest covered. There's really two types of interest. There's fee and there's leasehold. A fee is the absolute ownership of a piece of property. It is the ultimate way to hold interest and title. It means you can will it, sell it, encumber it, whatever it may be. A leasehold policy for you commercial side is for a standard lease. And they say they're leasing the property for 30, 35, 40 years. And they're going to get a loan to lease the property. Maybe it's ag building, maybe it's cold storage, whatever it might be. We can write a leasehold policy. So when you look at the preliminary report, you'll see that they'll have the estate or interest covered. Make sure something's there. If you're an agent and you get that report and there's nothing there, contact us. We made an error somehow. It should either state a fee or a leasehold. Okay. Um, the owner of the estate or interest, the next thing it's going to show is who we found a public record to be the physical owner of the property, the fee interest. And that's typically going to be your seller. Now, why is it important to review that? If you're an agent, you list a property and um, Bob Dittmeyer is the one filling out your contract and stating he owns the property, and then you get the preliminary report and it's not owned by Bob Dittmeyer, you might want to start asking some questions. Okay. There may be a perfectly reasonable explanation as to why. Um, his name isn't on there. Maybe it's his mom's property and she's given it to him, or somebody just passed away and he's going to receive it in some type through some type of decree of distribution or independent administrators act. Um, or we may have the wrong property altogether. And that's a good indicator that we need to start asking some questions. So if you see the vesting of the property differently than what you believe the seller to be, give us a call and let's talk about that. And then the next thing is the parcel of land involved. We're typically going to give the physical address of the property, the assessor's parcel number of the property, and then we will have the legal description of the property. All property throughout the whole country are described by legal description. That is what we insure by. We typically don't write a policy as to just to the address or the assessor's parcel number because those things can be changed. The legal description is the absolute description of the property, and that's what we insure against. You can change the legal description, but it requires going through the county and getting lot line adjustments, parcel map waivers, things of that nature, which are made of public record, which are easy to follow along with. There are going to be the exceptions, liens, encumbrances, and other risks, which will not be insured against if a title policy is issued. Again, the preliminary report is a wealth of information about the property. I really encourage you to read the report. If you have any questions about it, feel free to give us a call. And hopefully going through some of these items on here to give you a clear understanding or a better understanding of what we're doing on those reports. And I'll tell you why I think it's important. If you're a new agent or you've been an agent around for a long period of time, um, and you list a piece of property and this new husband and wife buyer, they don't know anything about exceptions and reports and title companies and closings. They just want to buy the house, right? And then you pop this preliminary report down in front of them, you say, hey, read this and I hope you understand it. And they say, well, what is this, Mr. or Mrs. Realtor? What is this item? What's it doing? And you look at them and you go, I don't know. Well, how does that make you look to the customer, right? I mean, we live in a very digital age of social media, Instagram, X, Facebook, whatever it might be. And as we know, the real estate industry is live and die by the referral. Okay. And if you're an agent and you're asked that question and you look at them and go, I don't know. I don't know. I don't know what that is. And then they get on Facebook or Instagram and or they're talking to their friend. They're like, hey, I had a dealing with buying this house. And boy, they didn't know anything. I would not recommend that. Well, their friend likes it, and then their friend likes it. The next thing you know, 50,000 people have seen this little post. Now let's take the same scenario and go the opposite direction. New couple asks the realtor, hey, what's an easement? What is that? And you're able to answer it at just kind of a basic, well, an easement is a right of
Generally,
another
mouth
party
open. Not a good look.
to go across your property, or the right of PG&E to have the north 10 feet of your property for power lines or something of that nature. And then, hey, they're like, wow, this guy knows what they're talking about. And then they get on their Facebook, Instagram, X, or whatever it may be, and they go, hey, I had a dealing with so-and-so realtor today. I'm buying this house. Boy, she really knew what was going on. She's on top of her game. And I really recommend that if you're ever selling or buying a home, to contact this person. And then their friend likes it, and their friend likes it. And next thing you know, 50,000 people have seen that glorious um, tale of all the things that you did. Okay. So I'm not saying you have to be a title officer or an examiner, but if you have a general idea of what some items are doing, it can really help you in the face of the customer going down the road. Okay. Other requirements and provisions which are reflected is the notes. And typically in the notes section, we will put a little chain of title of what's happened in the last couple of years, conveyance wise. Lenders like that, they typically require a 2-year chain. We may put something in there about the buyer and a requirement for things of, so read the whole report, even read the notes section. Assessor's parcel map. An assessor's parcel map, does everybody kind of know what an assessor's parcel number is? It's just the county's way of identifying your property to tax it. And that's it. That's why we don't insure as the APNs, because the county, as the county gets bigger and more neighborhoods are built, they change the assessor's parcel numbers. But they will change them. They will have an assessor's parcel map. All of our reports will come with it. It's just a little kind of drawing of what the property looks like. It gives square footage, things of that nature. Okay, this is what the first page of preliminary report is going to look like. If you notice, we have a highlighted section. This paragraph specifies that no liability is ever assumed under a preliminary report and further indicates what should be requested if the customer desires assumption or liability prior to title policy. Like we spoke about at the beginning of this class, a preliminary report is not the insurance product. The report is just a report we write telling you of what we're not going to be willing to insure against, what exceptions we're going to be having, as well as any problems that might have occurred through vesting, issues that we may find with legal descriptions, things of that nature will be all in the preliminary report. It is not a policy of title insurance, and there's no liability assumed by the issuing of that preliminary report. Next page. Now we'll get kind of to the meat of it. As you can tell by the first slide, this is the title number. Typically, escrow number will match if you're dealing with an escrow officer and the properties in the same county that they are. But if you're a outside realtor or an outside escrow company from a different office and you open it up, then the title number and the escrow number may not be the same because they may be in Fresno County and the property may be in Merced County. So the title order number and the escrow order number will not be the same. If you have correspondence with the escrow officer, always use her escrow number. If you're having correspondence with the title officer, always use the title order number. Like I said, most of the time it's going to be the same, but not always. Next. Again, we talked about the escrow contact, so we can move on. The next one is the property address. And typically most contracts are written with a physical address. This just is telling you the address that what was presented to us to open up the order for the preliminary title report. Again, review this. If it's not the same as what you have, give us a call. Let's make sure that we're all on the same page. For example, if you have a duplex, or if you're on the commercial side and you're doing a big apartment complex, the county will only take, even though the property has multiple addresses, the county will only take one address to assess the property by, right? So and we grab our information off the public record. So let's say you opened it on 1234 West First Street, or 1235 West First Street, and we come up with the 1234. It may just be because the assessor's office took that one address to assess the property by. But it's very important that you check that address, make sure it is the same as what you're um, dealing with and selling, because we want to make sure we're getting the correct property done. Next one. The effective date. We kind of talked about this a little bit. We typically will run about two weeks behind the actual date, but again, don't worry about that. As we get closer to closing, we will update that report. Most lenders require that report to be at least 30 days for their funding purposes, but we can beat that easily. Again, just typically 2 to 3 weeks, but we'll update it all the way to the date of closing. Next one. Okay, in this section, this is the type of policy that we're contemplating issuing. Our default policy for residential property is the Alta homeowners policy of title insurance. If you're dealing on the commercial side of this, um, there may be a CLTA standard owner's policy, an Alta owner's policy. There's different types of policies on the commercial side. Um, let's make sure that we're dealing with the correct type of property. If you're dealing with commercial property and it comes up at Alta homeowners, we can't issue that policy for large commercial transactions. So we made a mistake and we'll need to change that. So not always will it come up with Alta homeowners. It just depends on what type of the property is and what type of policy we can issue. But for most residential policies, our Alta homeowners is our default policy. The next one there is the Alta loan policy, 2006. Again, this person's buying this home and they're getting a loan with an institutional lender or a private lender, and they're requiring the Alta loan policy. We're just telling you these are the two types of policies that are contemplating being issued. The estate. This is where you're going to find either if it's going to be fee or leasehold. My commercial people out there, it could still be fee when you own a commercial property, but if you're dealing with the leasehold interest, it may say leasehold there. A fee simple is the highest type of estate or interest an owner can have in land, freely transferable and inheritable, and whose owner is entitled to possession. Um, you'll always see that there most property is bought and sold in fee. Okay. Vesting. This shows the owner of record and how title is vested, how the owner holds title and the land, i.e. a single man, a widow, husband and wife as joint tenants, many different ways to hold title. Um, you'll often get the question as agents from a new buyer who's never owned property. It's like, well, because you're going to ask them, how do you want to hold title? And they're going to say, well, how do you think I should hold title? Never answer that question. That's not for you to determine. You could be liable for doing that. Um, Chicago has a great list of different interests and how you can hold title. I think it's called the 8 Common Ways to Hold Title. I really would think that you would want to contact your sales reps. They can get you a copy of that. And that way you can pull that out of your briefcase, put it down in front of your buyer and go, well, these are the ways you can acquire the interest. What best fits how you want to acquire your interest? Don't play attorney for them and say, oh, you should be husband and wife as joint tenants, or you should be husband and wife as community property with the right of survivorship. Don't make that mistake because they can come back and get you in the long run. It's up for them to decide, and then they would relay it back to us on how they want to hold title. And as long as it's something we can do, this is what the deed would be drawn up on and how they would record coming into title. Because there's joint tenants, there's trusts, there's all sorts of different things. The next thing you're going to find is a legal description. Again, we insure as to the legal description. Have you noticed there's an assessor's parcel number right up above? And this is typical for our company. We're always going to give you what the assessor's parcel number is at the time that we close, but we're really insuring the lender and the owner as to the legal description. As you can tell by this legal description, you have the lot, the tract number, what city it's in, the county, what state, and then it has the recording book and page of the map. This is the actual recorded subdivision map and the lot itself. And this is what we're ensuring. Next. Okay. When you're looking at a preliminary title report and, hopefully using Chicago Fidelity Family reports for these, but if you're using Brand X title, we all pretty much do the same thing and show it in the same um, recorded order and manner. So that's why I think after you're done with this, if you can print this out, throw it in your briefcase, and that way you can always refer back to it. But a preliminary report and a policy of title insurance will show the items and how they affect the property. Item number one, item number two would be taxes. Why? Why do we do that? The reason for that is because the tax man gets his money first, period. I don't care if you have a $40 million deed of trust on your property. If you do not pay your county taxes for 5 years, the county will sell that property and at a tax sale, and that is legal. And it will wipe out that $40 million deed of trust. So most lenders require, on the residential side, they typically require that they impound those accounts so they can make sure that the county taxes are being paid. Not always, depends on the lender, but they know that they need to get those taxes paid first. And that's why we show them in the order of how we do. We're showing these items in the recorded order of how they affect the real estate property. Okay. The first line was just taxes showing taxes, in this case, 2019, 2020. If this was a report done today, it would say 2025, 2026. So that's taxes for next physical tax year. The amounts aren't out yet. They're not payable, but we're just saying we are not covering those. Item number two is the actual property taxes as they sit right now. We typically will show the first installment, the second installment. Um, if they're paid delinquent, we'll show the assessed value of what the recorder or the tax collector has for the property as well as the land, any personal property. So these are just the current taxes due right now. Item number three, or in this particular case, we put this on there, it's a tax default. So they haven't paid their taxes. And so they are defaulted with the tax collector. So what we should do is we typically will show an exception on the report showing that the taxes are tax defaulted and how much it is to redeem those taxes to bring them current. And we typically will put the month that we're in at the time, as well as the month after that. So in case the escrow goes a little bit longer, they'll have those amounts. The escrow officer will always call and check with the assessor's office prior to closing to make sure that there's no other taxes that may be owed. The next one are supplemental taxes. And this is an interesting exception that a lot of lenders, and even on the commercial side, we get this question a lot. This shows supplemental taxes which may be due or assessed on subsequent tax bills. We only report what's up public record. So if the county is in the process of doing some assessments, supplemental assessments, and they have not posted those of public record yet, obviously we would not know about them. So we have an exception in there stating that, hey, there may be supplemental taxes due that we're not aware of. We are not going to cover those in the title insurance policy. Well, how would that affect? Let's say I bought my house in 1984 and I only paid $84,000 for that house. And now I'm selling it in 2025 for $450,000.
But I'm like, dude,
Okay. Well, the whole time the county's only been taxing me on my $84,000 value the whole time I'm on the property. But as soon as I sell that property to the new buyer for a higher value, then the county will look at it and go, okay, so now I'm going to hit the new owner with a supplemental tax bill stating that these are the amounts that you have to pay to bring it up to the value that you bought it at.
You just mute
And,
the.
and you will get those, your customer
Uh-huh.
will get those on sale transactions. So we're saying that, hey, if we didn't know about the tax at the time, it wasn't out, it's not going to be covered by the policy of title insurance. Another reason that could happen is if you own a house and you get a permit to build a pool, well, guess what? Building that pool increased the value of your house, and the county will catch on to that. And what are they going to do? They're going to assess your property at a higher value, and you're going to get hit with a supplemental tax bill through the course of the year because that's their way of getting their money because taxes are only assessed one time a year. So when the taxes come out, they come out on the amounts. Anything they have to add, they have to do by supplemental tax bill. Next one. This is a Mello-Roos with taxes. Um, we do have Mello-Rooses in Fresno County. Um, and what that is, it's a separate tax that's added onto the tax bill. And it shows the property is within the district that has Mello-Roos taxes, which are included in the annual tax bill. Also states that these can be stripped from the taxes and foreclosed upon after failure to pay said taxes. So it's a separate tax that's added onto your tax bill. And it may be, there's all sorts of reasons they can do that. I won't get into all the ins and outs of them. Um, but what we're telling you there is if you default your taxes and you're not paying your taxes, then the Mello-Roos can come out of the taxes that you're paying because you've been paying that Mello-Roos through your tax roll. They can come out and then foreclose your property just like a county tax collector can. And it would wipe out anything that happened after that monetarily wise. A voluntary deed to trust, judgments, liens, things of that nature. It does not wipe out easements, things like that. But we want to make sure you're aware of those. If you see a Mello-Roos, you can typically call the county and they'll tell you what it's for. Covenants, conditions, and restrictions. This item indicates that there are covenants, conditions, and restrictions of which owners of this property are required to abide by. We kind of talked about that a little bit. Very important to look at because again, you know, it can say all sorts of things, where you can park your car, your trash cans have to be covered. You have to keep your yard mowed. You can't paint your house blue. You can't paint your trim purple. You can't have chickens, things of that nature. So if you see a restriction, not all restrictions are, all property have restrictions. Some of the older ones don't. And some of the newer ones don't as well. Typically, everybody does have some type of covenant, condition, and restriction. If you notice in that restriction, it says covenants and restrictions, but omitting any covenants and restrictions, if any, including but not limited to those based upon race, color, religion, sex, sexual orientation, familial status, marital status, disability, handicap, national origin, etc., etc., etc. Well, why is that in that restriction? I'll be honest with you, folks. You know, in early subdivisions, when Fresno County was first getting started, it was very racist. They would put on there that you couldn't be black and live there. You couldn't be Armenian. You couldn't be Jewish. You couldn't be Christian. You couldn't be whatever it might be. They would put these restrictions in there stating that you could not own this property. And they used to be a legally binding document. But you know, as we all know, in the 60s, that was abolished. JFK and Bobby Kennedy dismantled that act. And so anything that has to do with any type of racism or whatever it might be against whoever it might be in a restriction is automatically taken out. Now, but here's the problem. As a title company, we report what's a public record. And we're going to give you a copy of those original recorded restrictions, and you're going to find that offensive language in there. And we can't black it out. We can't take it away that way. We have to give you the document as it's presented. So, you know, it can be very embarrassing to put a restriction down in front of some people and have to explain to them that anything that has to do with that is automatically stricken. I bring that up because I know how uncomfortable that is, and there's some very offensive language in a lot of those old restrictions. Um, but none of that is in effect in today's date. Items 7 and 8, these are easements. We kind of talked about at the beginning of the class why I think understanding where your easements are is very important. In this particular case, we have public utilities easements. We will show what type of easement it is. It might be for a right of way, it might be for ingress and egress. You can grant easements to utility companies, private individuals, whatever it might be. But any easement we find of public record, we're going to post in the preliminary title report in the order that they affect. And as you can state, these items indicate they are easements of record affecting the land for stated purposes. When clearly defined, the location of said easement will be set out. These can be dedicated on or filed map or recorded as an instrument in the recorder's office. So what we're saying there is when you put a new subdivision map on and you're the builder, Lennar, whoever they may be, are building homes, they're going to record recorded track maps. And on those track maps, there's going to be dedicated easements for maybe cable television, power lines, Comcast. There might be easements for if you have landscape easements where they put trees in there, there's going to be easements for those so people can access them to trim them, things of that nature. If we can define where the legal description is based upon where the easement is, we will set it out in the report showing you various strips of land 6 feet in width, as you can see under item number 7. If we don't know where the easement is, we know it affects your property, it's recorded against your property, but it doesn't spell out exactly where that easement is. We're just going to put a portion of said land, or we're going to put the exact location of said easement is not disclosed to public record and can't be plotted. So we know there's an easement out there. The way title insurers work is if we know there's an easement out there, but we don't know exactly where it is, we're going to put it as an exception to coverage. So we get a lot of people saying, well, that easement's way across the street. And it's like, that's good and fine. And I understand what you're saying. But since the easement doesn't say exactly where it affects on what property, then we're going to exclude it from coverage and just say, we just let you know there's an easement somewhere out there. Where it is, we don't know, but just letting you know. Item number 9, voluntary. This indicates a voluntary encumbrance against the property for monies which are secured against the property. It will show the original loan amount, date, executed recording date, borrower, lender, and trustee. So this is a common deed of trust. The first thing we're going to show is how much the deed of trust was recorded for, when it was dated, the trustor or the grantor, the person who's borrowing the money, and what their status and tenure was. So they were husband and wife as joint tenants. The next one is the trustee. In this particular case, Chicago Title Company was the trustee. The beneficiary was Chase Home Loans, and it gives the loan number, recording date, and the recording number. So the beneficiary is the person who is the benefits loaning the money. They're the ones who get the money back with interest. The trustee is kind of like the impartial third party upon when the trustor does their final payoff to the lender, who's the beneficiary. The lender, the beneficiary, would then contact whoever the trustee is to prepare a reconveyance, eliminating that deed of trust off the property and off the public record. Does not have to be a title company only as the trustee. Aaron could be a trustee. Scott Hanley could be a trustee. Darrin Nichols could be a trustee. The bank could be the trustee. It's just the party that's going to be charged with finally getting the reconveyance after the original note has been paid off, signed, and delivered to the trustee, showing it's been paid.
And I
Next
just
slide.
want to pop in, Darrin, and say, if there's more than one deed of trust, how do they appear? And even if something seems old, it needs to be addressed, right?
Right. So when it comes to deed of trust, like we stated at the beginning, we show items on how they affect the property, taxes, then recording dates. So if you have a deed of trust from 2012, and then you have another one from 2014, we would show that deed of trust under in the recorded order of how they affect the property. Now, a lot of times what happens is you get old deeds of trust that are out there. Maybe they're 20, 30 years old with mom and pop as the beneficiary. Um, the kid owned the property, asked mom and dad for a loan. Mom and dad gave him, $70,000, recorded a deed of trust, but they never reconveyed it. Since as a title company, all we're doing is picking up what is public record, and that is in a lien or encumbrance against the property. If a reconveyance hasn't been recorded, we're going to show it. We're going to show it on that prelim. We're going to require that it be taken care of, or we will show it on the owner's policy and lender's policy for the new buyer. Well, the new lender is going to be like, no, I'm not going in second and subordinate to that deed of trust, but 30 years old. They're going to require it to be paid off. So as a course of that, the escrow officer would have to track down that beneficiary, order a demand showing that there's no money owed. And then they would have to prepare a reconveyance, get it recorded or record with our transaction before we would eliminate the item. Well, why is that important? Because all these things are recorded in priority order. So if you have a deed of trust that was done in um, say 2009, and then you have a deed of trust done in 2012, if that 2009 deed of trust gets foreclosed, then it wipes out that deed of trust that recorded after it, or any money encumbrance that recorded after it, or any involuntary lien that recorded after it. So we want to make sure before we issue this policy protecting a lender or a buyer, we want to make sure that that deed of trust has been reconveyed of record. So after we close, we insure the new buyer, and then somebody pops up and goes, oh, hey, by the way, I'm lender so and so, and I have a note and deed of trust recorded against this property, and they haven't paid me, and I'm foreclosing, and I'm taking the property back. Well, then we would have to pay to protect our lender, our insured lender, as well as our insured homeowner. And then we would take a complete loss on the property, have to pay it off or defend them. Um, to make sure that they were whole in the deal. So that's why it's very important. You're going to get this time to time, old deeds of trust that haven't been reconveyed, that we need to track down and get reconveyed. If they can't find the original beneficiaries, say it's 30 years old and they're gone and nobody can find them, then we have some options. We would have to get either a quiet title by the Superior Court, which takes time and money, stating that the lien no longer affects. We could go off that, or we would have to get a lost note bond done by a bonding company, assuring that if that deed of trust comes back up, that they will pay us the full cost of whatever it costs us to defend ourselves. So good point, Jennifer. You want to make sure that when you look at these reports, you don't have old deeds of trust that don't affect. But any other deed of trust that recorded after that, everything would be set in this report as how they recorded a record and their priority. That goes with commercial transactions as well. You may have options to purchase, memorandums of lease, secondary, third, fourth deeds of trust. Um, all those would be shown in the report and how they affect. So let's say you have somebody who wants to loan this person $1.5 million. It was a commercial deal, and they have this $225,000 deed of trust. And they're not going to pay off that $225,000 deed of trust, but that new lender who wants to loan them $1.5 million will require that the beneficiary of item number 9, the deed of trust, do a subordination, making their interest second and subordinate to the new deed of trust for 1.5 million. If something like that happens, you're going to find in the report, you'll show the deed of trust, and then under it is say said deed of trust is subordinate to that document recorded as dated and so on. So we will actually put on there that first deed of trust is now second and subordinate to the new deed of trust. And it would be shown on the report in order as how they affect. Next item, solar energy systems. You're going to find these on, we live in the valley, and the valley is full of sunshine. So we are the perfect little area for solar. And so a lot of people are going to solar to relieve them of the PG&E burdens that we all face today. Um, this indicates the solar system is presently located on the property in the terms of the recorded contractor and the effect regarding the system. So typically when they put one in, if you're financing it, they're going to put in the solar batteries and the mirrors and everything. Um, it will actually state what the contract is. The next item would be this financing statement for the solar. Like I said, you borrowed money in order to put the solar on your house. They're going to file a financing statement against your property, which is similar to a deed of trust. Um, so it's just one of those things that you have to look for that if you have solar. Um, we require typically that those be either released to the new buyer because maybe your buyer doesn't want the solar system. Hey, I don't want the solar system. So it would have to be removed and terminated by the solar company. And if you do buy the house and you're like, yeah, I want the solar, then you would have to assume that debt and that contract with the solar company. Okay. Through the report, like I said, you're going to show items that we're going to require. Um, a prelim will not only show things that are public record, but it will also show problems that we might find. And we're going to spell them out in the preliminary title report. Or if we have a trust, which is the vested owner of the property, or maybe they're the buyer of the property. And I'm not going to play attorney today because we could have a whole class on what trusts are. But a trust is just a way to avoid probate. It's you set out a trust. It talks about who your bennies are in the trust, who your heirs are, who the trustees of the trust are, what's to do with the property once you die and go away. Um, then the trust would take over, kind of like a mini probate, much cheaper, much less time consuming. And for tax purposes, I'm not going to play lawyer, but you may want to contact your lawyer and accountant of what the being in a trust does for your taxes compared to being as individual or so on and so forth. But there's many types of trusts. There's revocable trusts, irrevocable trusts. Um, a trust itself um, is the owner of the property, but a trust itself can't hold the fee interest. So you have to have a named trustee of the trust. Okay, so it'd have to be Darrin Nichols, trustee of the Darrin Nichols Family Trust, dated uh, March 21st, 2025. So Darrin Nichols is the trustee. He has the authority to sign for the trust. It's his trust. Okay. But in that trust, you'll typically find that it will state that if Darrin becomes incapacitated or dies, then this person now becomes the trustee of the trust. They would be called the successor trustee. And there may name one, may name three, um, all to act together. But typically, it will give two or three different people in order of how they will serve as trustee of the trust. So Darrin owns the property in his trust. Darrin's out riding his motorcycle one day, and Darrin passes away. The property is in the trust, so that successor trustee would have to record an affidavit of death of trustee, establishing a record that the original trustee has passed away. And then now he becomes the trustee of the trust and he can sign for the trust. I want to do a little caveat about this and trust in your vestings. If your seller is in a trust, please make sure that they have a bank account in the trust name. Because when escrow closes, they're going to cut that check back. And since the trust is the fee owner,
then it's the trust that gets that money. And then when you receive that proceeds check, if you try to go into your bank and deposit that check into your personal account, they will not do it. You have to have an account set up for that trust. And we run across that time and time and time again. So just be very careful of that. If you're the seller's agent, make sure that you tell them, hey, make sure that you have a trust set up, a banking account for your trust. So in those proceeds for the title company for your sale, they're cutting you a check for $500,000, you can deposit it into your account. If you don't, then they have nowhere to deposit it, right? So that's just kind of one of those things you want to look at when it comes to trusts. As a title company, I have to review a trust. For example, Larry Troy comes to me and says, "Hey, I'm selling this transaction. My seller is in a trust and he's passed away, and so I want his son William to sign as successor trustee of the trust." Well, the first thing Title Officer Darrin's going to do is ask to see a copy of that trust that shows what the succession of who is the successor trustee of the trust are. Because Darrin, as a title officer, has to make the determination that I have the correct trustee signing. Because a lot of times, when it comes to family issues, that's where we take a lot of claims, is between family members and sometimes in trusts. Because let's say Darrin let William sign as successor trustee. He sells the property is cut back to the trust, the proceeds. And then all of a sudden the sister pops up and goes, hold on, I'm also named as a successor trustee of that trust. And that conveyance deed would require my signature, and I didn't okay this, and I'm not okay with this transaction, so on and so forth. And you can see how a claim would arise from that. So as a title officer, I'm going to ask to see certain portions of that trust. Not always will I want to see the whole trust, because I don't want to be charged with knowing every little detail of their trust, but I do want to know little bits and pieces of it. As well as that, I'm going to require that the trustee sign a trust certification that escrow will provide to that trustee, that trustee has to sign, stating that they attest to the fact that they are trustee of that trust, they have the right to sign for the trust, so on and so forth. And that gives us some protection if we have to appear in court. Okay. You also will see requirements sometimes for statement of information. Well, let's talk about what a statement of information is. It's a document that we have the buyer or the seller fill out when we find a lien against a common name. Understand that we're not only searching for voluntary liens such as deeds of trust, we are searching for involuntary liens, abstracts of judgment, child support judgment, federal tax liens, things of that nature. And let's say you have a common name, John Smith, Juan Hernandez, or whatever it might be. We run those. If you run a very common name, you'll get, and in fact, hold on, let me just run one. So I'm going to run Juan Gonzalez. So on Juan Gonzalez, right now, there's 1,334 judgments and liens recorded of record. Darrin, as a title officer, has to go through every one of those and make a determination of is that the same John Smith that I am dealing with as my seller or buyer. Okay. And then I have to make a determination whether they affect the real property or not. Well, how can I do that? Since you're always not going to get a social security number on a judgment. It may just have an address or what they do for a living. So the statement of information gives pertinent information about your buyer or your seller, is used only for us. It does not get sold. It does not get out to the world. You got to understand, we're regulated by the state insurance commissioner. It's against the law for us to be able to do something like that. And I would take that information, I would compare what you do for a living, where you've been for the past 10 years, what's the name of your children, who you married to, when did you marry them? And I would take that information and then, based upon my years of experience, determine whether or not that judgment is my seller or buyer, because I have to deal with them. Right. So it's amazing. We get all the time back from people. Well, they don't want to fill out an SI because they're afraid of their identity being stolen, because it does give a lot of very pertinent information, which is very interesting. They will give the lender any information they want. I mean, heck, sometimes they may give them the first child. It's like, hey, I'll give you whatever information you need to get my loan. But a title company asks for it to make sure that we understand what judgments and liens are. And it's like, oh, well, no, I don't want to give that. Well, if you want to close, you're going to provide it to us, especially if you're on the seller side, right? Because an abstracted judgment, a child support judgment, a federal tax lien, a state tax lien, guess what? They can be foreclosed. They can do a judicial foreclosure. They can take your property for non-payment of judgments and liens. They can start a judicial foreclosure. And if they do that and win, then my new buyer that I just insured would be at a total loss. I take a total claim. Right? And so we don't want to do that. We're not a liability company. Right? We want to make sure all of our T's are crossed and our I's are dotted. So we're going to require some information in order to clear judgments and liens. Now, I'm not saying that if we find a judgment and we can't clear it with the information provided, there's just not enough information on it. Sometimes we can work around it and we will find a way to get this thing done. It might be as simple as just showing it on the owner's policy. And if you're a buyer, not always to be run buyers on residential transactions. We do on commercial transactions, but we don't on residential side. But we still want to know what judgments and liens are out there to make sure that they would be under the guidelines of a purchase money deed of trust, to where the purchase money is the utmost. You're taking all that money to buy your house, then it would set that lien in second position behind it if you're a buyer. Doesn't mean the lien goes away. It just means that the deed of trust would have priority over it. This is state law. Okay, so we can use that sometimes, but at Chicago, we want to make sure that you guys are aware of these things up front. So when your buyer comes into title as a purchase money deed of trust, they have a judgment or lien and they go to sell it or they go to refinance it, that lien's going to come back up and the title company is going to require that it be taken care of. And that buyer is going to feel, well, I just closed with Chicago Title and they didn't tell me anything about it. And they didn't show it on my owner's policy and la, 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 la. Well, that's right, because we treated it as purchase money, but now you're the seller. That's a different animal. Now you're asking for a new loan, and that lien would have precedence over that deed of trust. Lender doesn't want that. It's a new animal. Okay. So, but we like to take care of all that up front instead of brand X title, who doesn't tell you any of that. They just close, and then your client comes back to you in 2 years and goes, hey, you were my buying agent, and I want you to be my selling agent. And you list the property and you have a $50,000 federal tax lien out there you have to deal with. And they start yelling at you, well, you closed this last time. You didn't tell me anything about this, like they didn't know they had a lien, right? But still, I'm just saying it can come back on you. So we like to kind of deal with that up front, especially on the our transactions. So those are just some of the things that you're going to see on a preliminary title report. Just understand that we're going to show things in the recorded order of how they affect the property. Taxes would be first. Anything recorded, easement by date, deed to trust by date, recording date and time. We will show anything that we find wrong. So we may, in the vesting, it may say something, Darrin Nichols, a married man, subject to item number 13 of this report. And then item 13 is a problem with the legal description 3 transfers of deeds ago, right? Well, this is a problem, right? So we're going to let you know that this vesting is subject to fixing all these things. And we will typically put what the problem was and what you need to do to fix it. So you'll see that in the report as well. So if you see that a subject to, go to that item, It will explain what the problem is, what we want to do to fix it, or what has to be done to fix it, to get it done. Okay. Another thing you'll find on it is the assessor's parcel map. Again, this is just what the assessor's showing you as what your property looks like. We don't insure as to assessor's parcel maps. They're tax maps, but we do provide them for your convenience so you can kind of see where it is relevant to streets and things of that nature. Okay. And that kind of does it with the prelims. We also have live look prelims or hyperlink reports, especially on commercial deals. It's more or less just a report that's issued, and it has a little blue hyperlink. So if you ever want to look at a copy of the recorded document, you click on it, a copy will pull up. We do this for free. It's just part of our services from Chicago Title. I think all the residential reports will go out on that side as well. Typically, I'm a commercial title officer, not on the residential side. But I know the residential side does it as well. Okay. And if Jennifer wants to talk any more about that with you guys, or how to do live look or how to get that, feel free to contact her.
I think we had one question that was like, what kinds of things do people get sued on? So I was just throwing this up to show that, these things can interfere with title, but if we miss them or something happens, these are the things that people tend to get upset about. But Darrin, what would you say are the most common things? The whole list will go out with the slides and things, but what are the types of things that you see getting claims on the most often?
Yeah, and that's a good point, Jennifer. And instead of having to go through every one of those item by item, most claims that we see, and they can vary, okay, but one would be missed financial deeds of trust, where we missed a deed of trust of record. We would take claims on that. Vesting errors, we didn't vest the properties out properly, or we missed an interest, we can take claims on that. Access easements to and from property. Again, if you're dealing with mountain property, there's going to be typically easements to getting back and forth because it doesn't butt up against a road. We can take losses on those if we don't do our jobs right. Judgments, misjudgments, liens, things of that nature. Missed taxes are a big one. If we didn't get the taxes right, we could suffer claims on those. That's why it's very important to, get a title insurance policy. It protects you from such a vast array of problems that, if we do our job perfectly, we shouldn't take a claim at all. Everybody should know everything up front, and everything should be hunky-dory. But it's an imperfect world. We're imperfect people. We're still humans writing these reports. Some people think that we do it with computer systems. That's not true. These are written by a human being who searches the property back all the way back to patent when the government first stole it or sold it off, and maybe patents from the King of Spain, because we do have some Spanish land grants in Fresno County. So we're charged with chasing everything back. Problems do happen. But some of the claims, we take a lot of claims with forgeries. We are very, very into stopping any time of claim of forgery. So we compare all signatures. We have all sorts of safe spot things that we do to stop forgeries. So if we ever, bring up maybe a signature doesn't look the same from when a person signed to when a person signed later, don't be offended by that. It's just us doing our job, so your customers can maintain their homes and we don't take claims.
We also got a question, and I want to just make sure I'm giving the right answer. We pay out to the property owner. So if vestings are under multiple trusts and a property sells, each trust would receive a check for their portion. We can do that. We just can't pay. If there's 3 people that are supposed to be paid out of a trust, we're paying the trust, not the individual people. But if there are 2 trusts, that money will be divided as per the instruction of the parties.
And that's correct. You know, us as a title company, we have two trusts in title. We have Jennifer Shepherd's Family Trust as the 1/2 interest, and Darrin Nichols Irrevocable Trust as the 1/2 interest. When we close, those proceed checks are cut back to those two trusts. It is up to the trustee of the trust to disperse that money within the trust itself to all the proper peoples that are named in beneficiary and how they're supposed to receive the assets of the trust. That is not us for a title company to do. Um, you know, that is done. That's why you have trustees of the trust. Title companies don't do that. We're going to cut our funds back to the trust itself, and then the trust will disperse the funds as they're supposed to by the rules and regulations of the written up trust.
Perfect. And then one last question that we did not address was, do you know of any Mello-Roos districts in our counties?
Well, there are Mello-Roos in Fresno County. Some in Sanger, some in the outlying areas. Does one pop up, you know, to my head as I speak right now? No.
Is
But
Tesoro Viejo a Mello-Roos
I do not know.
community?
I
Okay,
do not know.
it'll
Again,
be on the prelim.
you to be on the prelim. You catch me a little bit of a disadvantage because I'm a commercial title officer, so I haven't been doing a lot of real residential stuff lately. So I haven't seen all these new subdivisions out there, restrictions and stuff like that. But there very well could be. But we will clearly state on the report if it has Mello-Roos. We will state that it's Mello-Roos. The majority of the property in Fresno and outlying areas are not. But there can be. You know, a Mello-Roos can also be something like if you used financing, let's say your air conditioner blew up and you entered in some program from the state that they would install new air conditioning system and heater in your home as you know at a low interest but it's you know good for like 30 40 50 years and they get their money by putting in your taxes and your taxes raise up a little bit, right? Um, but that's where you could find something like that type of Mello-Roos to where if you don't pay your taxes, they can come back out of that and then try to foreclose you for that.
Well, one of our attendees shared in the chat that yes, Tesoro Viejo is one of those Mello-Roos districts. I know that we've run a little bit over on time, so we understand if you need to scoot. If anybody has any other questions, you're welcome to stay on for just a minute and unmute and ask those questions. And I do want to take this time to thank you, Darrin, for another amazing presentation. We always appreciate your insights and wisdom and look forward to the next time that we get to have you on a Zoom. And we will send out the recording at the end of the day, probably. If you get that recording and you're interested in the slides or any of the other documents that Darrin referred to, don't hesitate to reach out to me or one of your sales team. All right, at this point, we'll just open it up for any other questions, but if you have to leave, thank you so much for joining us, and we appreciate you.
And remember, I'm much better live.
Yes, we will be roping you into a live class before
I do the manga and everything. It's great. Can't miss it.
All right, I don't see any other questions or anything like that, so I am going to stop recording.